Sanctions for ignoring court orders. The Ontario Court lays down the law in a recent decision. Spouses were embroiled in a dispute over spousal support and related issues. Wife had persistently failed to provide financial disclosure, despite specifically ordered by the court on several occasions to do so. The husband applied to have the wife's claim dismissed entirely. The court examined the general rules and principles that should guide a decision on whether this sanction is appropriate for the wife and others like her, in the face of persistent disobedience in complying with family court orders. The Ontario Family Law Rules affords the court with a broad list of potential sanctions anytime a party fails to obey an order in a case or a related case. Among them, noted the court, was what it called the nuclear option of last resort, dismissing the offending party's claim altogether. This brings the entire claim to an end, not just the litigation. Prior Ontario family law cases, where courts offered no-nonsense admonitions to litigants who persist in ignoring orders, the most basic obligation in family law is the duty to disclose financial information. The failure to abide by this fundamental, immediate, and ongoing obligation, the court examined several cases on non-disclosure. First, the court noticed it impedes the progress of the action, causes delay, and generally acts to the disadvantage of the opposite party. It also impacts on the administration of justice. Unnecessary judicial time is spent, and the final adjudication is stalled. Financial disclosure, the court noted, is automatic. It should not require court orders, let alone 3, to obtain production. The second case the court looked at, the court stated, an order is an order, not a suggestion. One of the reasons that many family proceedings degenerate into expensive merry-go-round ride of disclosure is the all too common casual approach to disclosure compliance with court orders, stated the court. The third decision that was examined, the court stated a party should not have to endure order after order after order being ignored and breached by the other side. A refusal to disclose one's financial affairs is not just a misstep in the pre-tactical game that deserves a 2-minute delay of game of penalty. Failure to disclose is a breach of the primary objective of the family law rules, especially if it involves a breach of a court order. The party who fails to disclose invites a determination that he or she does not want to play by the rules. It is time to oblige such parties in assessing a game misconduct to eject them from the proceeding, the court stated. And finally, a fourth decision that was reviewed, the court noted the following. A just determination of any family proceeding is rooted in the protection of the administration of justice as a whole. And when a party chooses to consistently disobey a court order, the administration of justice itself is called into question. After noting these governing principles, the court in the case that we're examining today found it was an appropriate remedy to dismiss the applicant's claim outright. Thank you for watching today. There's a bell that you can ding at the bottom to get notifications of our upcoming vlogs. You can subscribe, you can share, you can like this post. If there's a comment box at the bottom, you can leave your comments or questions. We're going to endeavor to answer everybody's questions at the end of each week. I'm Russell Alexander.